Dear participants of our roundtable, we decided to set an example here to everyone and to take off our coats. So an act of self-revelation. Why didn't you tell us before? Because we could have organized this meeting at the Constitutional Court in an air-conditioned room where everything would be fine. Well, you know, it just worked out that way. I think we can start taking into account the fact that the chairman of the Cassation Court of France is going to join us in a moment. He will come along. He probably has got lost somewhere on the way. Our roundtable is devoted to such issues as the development of national and international justice, challenges, reforms and prospects. This is a rather topical issue because justice cannot exist in a frozen state. It should always reflect the ever-changing relations in society, and the stronger the change in the relations, the faster the system of justice should change. This is the main challenge with what refers to the system of justice. If courts of law do not change and make everyone else adapt to themselves, this leads to rather bleak outcomes for the legal system as a whole. So I think that the main challenge for courts is to be up to date, to develop alongside the situation in the society, and maybe sometimes even be in front of changes. And our roundtable discussion is aimed at identifying certain paths for further development of the judicial system. And for Russia and many countries participating in this forum, this means that to a large extent we'll also be talking about the reform of the European Court for Human Rights, which has been announced. And I would like to give the floor first to Anatoly Kovler, a judge of the European Court for Human Rights, who has amassed a wealth of experience working as a judge at an international court, and he will of course update us and give us the latest information about the reform at the Court of Human Rights, if of course he supports these reforms. Thank you, Anton, for this privilege. It is for the second time that I participate in the work of this forum and in a roundtable discussion under your chairmanship, and for the second time you are making me first to speak. This is a trend, I think, already. I'm very thankful for this privilege anyway, and in the questionnaire that I received, at least, I chose the topic of conversion of legal traditions of continental and common law. This topic was already dealt with to this or that extent at the plenary session. Of course, I will also refer to the case law, to the practice of the European Court for Human Rights. In comparative jurisprudence, thanks to Ron David, the term of legal families has been established. We have a continental legal family and a common law legal family. Each of these families have its specific features. Each of them is relying on centuries-long tradition, and until now scholars continue to argue whether a precedent can be deemed to be a source of law in the continental system, when we know different answers to this question, and the question is whether they are compatible, because the methods are very different. The methods for arriving at court decisions, the categorical system is different, the regulatory frameworks are different, and the globalization that we discussed earlier here today confronts us with the following reality. We need to find an answer to this question, among other things, and in this respect I think it would be appropriate to study the experience, the case law of the European human rights, which spans 52 years, where these two legal families meet each other. The convention as such is not a lengthy document, slightly in excess of 60 articles. Out of them, only 1/3 is devoted to material law. Everything else is related to the organization of the work of the court on procedural matters. From the very beginning of the court's work, there arose a need to interpret very brief provisions of the European Convention for Human Rights, which provided the basis for consensus amongst the founding countries, and we tried to provide an enriched interpretation of certain provision of the Convention. Here, the European Court for Human Rights, in a well-known case of Tyler versus the UK of 1988, the convention was called a living instrument, and this term is widely used. So this convention is applied depending on the circumstances of the case, and provisions of the convention can be interpreted differently compared to what the interpretation was 10 or 15 years ago. At the same time, the court was not trying to impose its methodology to national jurisdictions, and 2 years later, or rather 2 years earlier, in Handelsite versus the UK, the court for the first time explained the principle of subsidiarity, which is according to which the law of the European Court of Human Rights is a complementary remedy which can only be used when all the national remedies have been exhausted. And the national judge is better placed, as was said there, better knows the application of local legal provisions than a judge in Strasbourg. So these two doctrinal statements were made by the Court of Human Rights in Strasbourg, and in this way the court started to develop the provisions of the convention. In 52 years, the court issued 13,000 decisions. Not all of them are set precedents. Not more than 10 or 15% of them are those that set precedent. All of them, all the other are clone decisions. This does mean that any lawyer, any judge can try and find something in this heap of 13,000 judgments that are of greatest interest to them and refer to them. No. So the case law of the European Court of Human Rights is similar to Chinese graphology, where they have several thousand basic hieroglyphs, on the basis of which hieroglyphics develop further and additional signs are added to words attenuating the meaning. Here we have a basic set of precedents around each article of the conventions that do apply and are applied. So what are the advantages of such a convergence of two legal systems? I think that this gives us a more flexible way to apply the fundamental rules, taking into account the merits of each case. So this is a case-by-case approach, so to speak. And this gives us an opportunity to clarify the position of the court depending on the requirements of each particular case. I would like to give you the following example. Maybe for Russian participants it will be very interesting. It's the case of Bigayev versus Greece. We're talking about a Russian lawyer. She graduated from a university in Athens. She speaks wonderful Greek. She was admitted as an intern at a law firm, and when in a year time came for her to be hired, she was refused because she is not a citizen of Greece. And by a small majority of vote, the court saw here an infringement upon the 8th article of the Convention. And the 8th article deals with the private life and personal secrecy. So, the privacy. In this case, the law decided that the professional life of any lawyer is part of the personal life, private life of a person, and if you deprive a person of professional prospects, the authorities of the Greek Republic infringe upon her right to have a private life, because she had certain private plans. So, and this way, the law provided a broad interpretation of Article 8. The court proceeds from the assumption that it is not bound by national legislation in accordance with the doctrine of autonomous interpretation of national legislation. It may provide its own interpretation of the provisions of national law. Let's take the case of Prokopowicz against Russia, 2006. People were evicted by force from an apartment in Vladivostok. This lady, Prokopowicz, was thrown away by her stepson after her civil husband had left her. And the court in Vladivostok stated that it was correct because she hadn't been registered at that flat, but although she had lived there for a long time. And the court in Strasbourg found a violation here. They said that a residence is an autonomous right. It is not a person should not necessarily be registered there. It is a place where a person lives. So autonomously, the court provided a more broad definition compared to our residential code. And I can give you dozens and hundreds of such examples. And here, the court also tried to prevent unnecessary, undue interference in national legislation. So this doctrine of margin of appreciation is good because it gives a government which has recognized the jurisdiction of the European Court to apply in accordance with national specifics this convention. To apply this convention in accordance with national specifics within a certain boundaries. Therefore, we are talking about a margin of appreciation. And the court in this case agrees that with regard to those rights which are not absolute, the court can give their own interpretation of such rights as the right of conscience, right of association, right of personal life. So this is a two-way street in a way. Of course, the system in itself as such is vulnerable as any system. And I see the main vulnerability of this system from the height of my experience of working in the court. This is the possibility of subjective interpretation of certain fundamental norms and provisions of the Convention, which is manifested in a number of cases such as the Lashko case, the Kononov case, Hiss versus the UK case. Those cases turned out to be very popular, and they kind of provoked a very negative response in the countries involved because the court here transcended its own sphere of remit. But those are, you know, the disadvantages of such this marriage, let's say, between the two legal systems. And of course, this system also also can be manipulated. A lot depends on the understanding of various judges about their attitude to life, and those disadvantages, they are unavoidable in any legal system, and no one has abolished the right of the discretion on the part of the judge, but all these problems that have accumulated and led to a situation where the three conferences in Interlaken, Izmir, where the countries raised the issue of compliance with the principle of subsidiarity. If you haven't read the Brighton Declaration, that was the latest meeting, there one of the top priority tasks is, in terms of reforming the court, it was stated that the preamble of convention should contain the provisions against the margin of appreciation and the principle of subsidiarity. So the role of the court is subsidiary, and also the state has a margin of appreciation interpreting the convention. This process is interesting. It is unavoidable. We should not dramatize it. We should not try and look for certain political and other undercurrents here. Of course, certain issues are politically very delicate, but on the whole, the intention to make those principles just a tradition, but it should be enshrined in the law as something to be guided by on the part of the court. About the further reform of the court, you asked me, Anton. Well, of course, the court does need a certain reform, if only because it has a backlog of complaints complaints that are repetitive. Out of decisions that we take, 60% are clone decisions, and governments tend to largely ignore those decisions. The court makes dozens of decisions on the one and the same case. The government pays out compensations, but do not resolve the problem of general measures. And this is not because they are not willing to. The court, and this is my subjective.
The decision Ananyev versus Russia, saying that this is a problem of the systems, the measures should be taken, but I believe that this is not a purpose of the court, which has a lot of other concerns to point the state of common measures. That's why in the last pilot decision Ananyev versus Russia in 10th January 2012, the court decided not to prescribe the Russian state as a state respondent any concrete measures to improve the situation in investigatory isolation wards. The court suggested the Russian officials to present before the Committee of Ministers the program of measures directed to improve the situation in investigatory isolation wards in order to implement it step by step. I believe that this is the rational methodology, and the same methodology should be accepted in the similar Polish case considering the situation in Polish wards. Therefore, we see that the court is not one-dimensional executor of the will of the Committee of Ministers, but it is also trying to develop and adopt this rather adaptable practice. It seems to me that in spite of the side effects which are unaffordable, it is possible to state as a resume that it seems to me that in spite of the side effects which are unaffordable, it is possible to state as a resume that the meeting of the two systems has come off. Listwise in Strasbourg it resulted in mutual pleasure and increment of both systems. The reverse impact of the continental on the common law system may be illustrated by the well-known case when the Human Rights Act was approved in the UK. May be illustrated by the well-known case when the Human Rights Act was approved in the United Kingdom. It is a separate law on human rights obligatory to be applied by the British courts. It is for the first time when a written law is accepted in the United Kingdom, which has become a revolution and created some shock by British judges who are used to open dusty volumes of precedents and find suitable ones in the collections of the 16th century. That's why I think that the tendency is mutual and doesn't enthuse everyone. But in my opinion, the fact that the meeting has come off shows that it may become a model for approaching of the two systems in globalizing world, when these systems collide indeed in the international arbitration and international criminal legal procedure. And we should take attempts to apply this methodology subject to some peculiarities of these systems. That's what I want to say briefly, taking into account fields conditions for our round table, and will be opened. That's what I want to say briefly, taking into account field conditions of our round table, and will be open for questions after other participants' speeches.
Thank you. I would like to grant the floor to Marko Ileshich, judge of the European Court of Justice, which is a very important court for the European Union and has a high moral authority. And of course, its legal stance may be taken into account by other countries, which is very important for the Russian Federation inter alia. The problems that they come across are similar to ours, and it would be appropriate for Russian judges to have a look at them too. The floor is yours. Thank you very much, Mr. Chairman. Our wedding of legal systems in our court is slightly different. First of all, I would like to thank the organizers for the invitation to say a few words about the court practice in the European Union. Don't be scared, it won't be a lecture, it won't be a report. I would like to highlight a number of issues that might be of interest for lawyers of all over the world. I do speak some Russian, but there are problems with legal language, so allow me to continue in English. Obviously, I can't speak Slavic here. That is my mother tongue.
In English, because it will be easier for me and you won't suffer that much listening to my Russian. Three phrases. Very well. So the court in Luxembourg, as I announced, as everybody is familiar, is quite a different court compared to that of Strasbourg, of which my colleague Kovlar just discussed. Because, of course, it's a regional organization which is much more limited. We have, as you know, 27 member states. We'll have 28 next year when Croatia joins, which is half compared to 47 of the Convention of Human Rights and the Strasbourg Court. And of course, also the role of this court is different. But I'll just stress a little bit the differences which perhaps will be helpful for development of thoughts of somebody among you. Firstly, if you can, you know it, but I'll repeat it because I like to do it. When the court was created in 1952, there was just one European community for steel and coal, established between 6 member states, the 3 Benelux states, Italy, France and Germany, after the World War II. So it was a means to conciliate a little bit all the traumas of the World War. And it was created, the community, and at the same time, in the same moment, the Court of Justice was created. The community of steel and coal was declared to be a community of law, which seemed perhaps at the time to be a symbolic declaration, but it was not, as the time showed afterwards. At the same time, the court in Luxembourg, an English professor wrote about our court that we are hidden somewhere in the fairy wonderland of Luxembourg. We are a little bit hidden, but our voice is to be heard. And of course, the first president of our court, it was the Italian Massimo Pilotti, quoted at the opening ceremony of the court, it was in December 51, that he quoted Dante Alighieri, the famous Italian poet, saying, "Ubi litigium esse potest, ibi judicium esse debet." What could be translated into English? Where there is a possibility of conflict, there must be a court. So a court was established just for the case if any conflicts will arise. And in fact, if you read the history, there haven't been a lot of conflicts, a lot of cases in the first years. But after it augmented, it increased. And of course, now the situation is quite difficult. With 27 member states, 27 judges, we have a big job to do. What is the specificity of this court in Luxembourg? It's an international court, but it's the international court, also the Strasbourg one. It's composed of 27 judges for 27 different countries. You can imagine what a complicated consultations we lead, or deliberations between us. 27 judges, more or less, we are all of the same age. That means not too young or not very young. And of course, with 27 different faculties of law behind us, 27 different professional careers, so we are different people. So to conciliate all these different ideas, I'll repeat the reference to the possible conflict between the common law principles and the continental civil law principles, which are not that much visible in our court, but nevertheless it's quite a work. So the result of our court, a judgment, is always a compromise which is, I am sure that you are familiar with some our cases. The result is not an ideal one, because of course I read sometimes a slogan from a Canadian professor of law who said, who asked himself or the public, have you ever seen a good poem to be written by a committee, by a collegium? The answer is, the question is a rhetorical one, obviously. And the same thing is for a judgment or a law. When there is a group, the result can't be good And the bigger is the group, the worse is the result. That's natural, that's human nature. And so the results of our court, the final judgments are sometimes very ambiguous, not clear, but this has to be taken into account. This is one specificity which, of course, national courts normally do not face. The second one I would like to stress is the linguistical regime, the language regime in the European Union in general and in the court in particular. All the 23 languages in the European Union are equal. They have the main value. So from the practical view, if I may tell you, I use English language in Luxembourg as much as the Slovenian one. So it's not a big difference in our internal work, where the working language is, however, the French one, but not the English one. So national courts, which may pose questions for preliminary rulings to our court, they make it in their own national language. The communication between the court, which is the highest court in the European Union, not exactly the Supreme Court, and the national courts is always in the language of the national court. The idea, the philosophy which is behind it is that every national judge in any country in the European Union must have the access to the judgments of our court in his original language. He's not a judge in a small court in a small village or small town somewhere in Slovenia or in Malta or in Lithuania is not expected to understand English or French or some other language. And this is consequently carried on. All judgments are published on the same day, in the same moment, in all 23 languages. They are pronounced in the language of the procedure, but all other translations are available. This also shows a bit the enormous, if I don't exaggerate a little bit, but quite big role of our court, because it's the rule which has been accepted in all the member states, in spite of the fact that it's nowhere written down. Our decisions, our judgments have the impact of a precedent. We said that the law interpreted is like the law itself, so it binds all the national courts, and all the system is directed with this intention. And just to terminate, because we are numerous, and I would stress, I would like to inform you, but perhaps you know it, that of course also the countries which are not member states of the European Union can be affected by our judgments. I'll take the example of Russia, because we are here in St. Petersburg, but I could speak also about China or United States of America or Australia. There are several judgments which affect directly interests of Russian citizens or Russian enterprises. I'll mention just two. We had a case which is known under the name of the plaintiff, which the friends of football will know. Igor Simotenkov was a Russian player who played in Spain for Real Club de Tenerife, and he didn't get the permission to play there as a member of European Union. And the case came from the Spanish courts to our court in Luxembourg. The plaintiff, Mr. Simotenkov, based his appeal, his demand, on the treaty between the Russian Federation and the European Union, it was European Communities at the time, concerning free movement of workers. And our court had to interpret this bilateral agreement, Russia, European Union, in order to find out whether he was right, and he was right. So we decided. And there was, just to mention another Russian case, it was a big cartel restriction of competition case concerning the world market of diamonds, where there was an alleged cartel between the Dutch Luxembourg enterprise De Beers and the Russian enterprise Rosa. I think it has its headquarters in Verkhoyansk or somewhere in Siberia with the big diamond production. And of course the cartel found itself before our court, and we had to decide. And just my last word, because in the agenda I found that the organizers of this roundtable would like also to comment something on the cooperation between courts. I won't talk about cooperation between our court and national courts concerning the concrete procedures. It's clear from all the regulations how it looks like. But we have several informal contacts with courts of member states and of other courts. Of course, my colleagues are now today in paying a visit to the Supreme Court and Constitutional Court of Romania, for example. And as Mr. Zorkin and Mr. Ivanov also see, too, our court paid a visit of a numerous delegation to the High Commercial Court in Moscow and to the Constitutional Court here in St. Petersburg a month ago. So we are open and we like discussions. And of course, the Strasbourg Court, this is a special problem. We could consecrate a whole day to discuss it, but of course we are separate. We belong to two different international, regional, European organizations, but nevertheless, firstly, it comes that the same case or a very similar case arrives to both courts in the same moment, or with a slight time difference. And secondly, as you know, via the Lisbon Treaty from 2009, the European Union acceded to the European Convention for Human Rights. But what does it mean for the competition between the two courts is not quite clear, because the Council of Europe and the European Union have to conclude an international agreement, and if I'm well informed, the negotiations are going on, but they are not finished yet. So we also visit Isaja, Luxembourg, and Strasbourg is not that far, and I am looking forward that the cooperation will be very good also in the future. Спасибо, господин президент.
Thank you, Mr. Chair.
Well, amongst members of our panel, we have not only judges of international courts, but also we have chairs and judges of national courts, whose role in the development of the system of justice is by no means less important. And now I would like to give the floor to Mr. Vincent Lamanda, Chairman of the Cassation Court of France. I have the privilege of knowing this person since 1998, when he was a judge of the Court of Appeal in Versailles. And I'm very happy to see him here. You have the floor, please. Thank you very much, Mr. Chair. Your words about national courts and national jurisdiction that I represent and how they combine with international courts, European courts, the question was probably like this. Well, in our changing, ever-changing world, the judicial system of necessity need to develop and change. However, the fundamental document of the European Union gives us the freedom in terms of organizing its own judicial bodies, and this is a good thing. As I said this morning at the plenary, history is very important in the field of law, in changing the system of justice and judicial procedures. This principle of procedural and institutional autonomy lies at the heart of the system of justice of the European Union. In the absence of general rules and regulations, internal law and order and procedures should be spelled out by competent jurisdictions. They should resolve all procedural issues related to the protection of rights enjoyed by the citizens. And those rights which directly derive from the general European law, and they should be interpreted by national systems. However, national judicial systems of necessity have been under an influence of the European Court of Human Rights and the Luxembourg Court as well. Taking into account the need to observe the principles of effectiveness, equivalence of the decisions of the European Court. What refers to ambivalence, well, procedural circumstances when considering any situation related to the infringement upon rights and freedoms, well, they have to take into account domestic specifics. A national judge must be confident that a transboundary litigation involving the EU law should be resolved in conformity with the guarantee envisioned for domestic procedures. So the judge must check the reasons and major components of the case. The principle of equivalence, and I can illustrate it with the following examples. There is a court case. There was a court case. There was a prudential question that was submitted for the consideration of the court in Luxembourg. The court was the only court that at that time could interpret the European law. Each judge can, when he is the court of last instance, like the Court of Cassation, must raise the issue of compliance to the European law. The situation was like this in that particular case. A UK tourist was robbed. Someone robbed him of his, or maybe stole a wallet at a Paris metro station. He was pushed down the staircase there, and he broke his spine, and he was paralyzed. In France, the system is very advanced. The compensations to victims of crime, even if the perpetrator was not found, the government undertakes to pay out the compensation. So that, but the text was that only those people who pay taxes in France can receive compensation provided by the national authority, which was, and the British citizen said that this was against the European law, because the beneficiaries were, the number of beneficiaries was restricted to those who pay taxes in France. And I applied to the court in Strasbourg, and I was told that yes, the French law was against the European law, although a similar compensation was not in place in the UK, if he was in a similar situation in London, he would never get a compensation. But this is not a problem of this is a problem of equivalence of judgments, and it means that any tourist in Paris must enjoy the same right for compensations like a person like a citizen of the European Union. And this is a limitation of the freedom of movement if only the French could receive such compensation. So we had to change the French law. Accordingly, the Parliament voted for a new bill, and those compensations were thereon provided to all the citizens of the European Union. Another principle is the effectiveness of the judicial system. Procedural norms should not be an obstacle to the enjoyment of rights provided by the European community. The national judge should take into account the entire circumstances of the procedure in various national court instances. Here we need to see what kind of basic principles, underpinning principles were in place, such as the protection of the right for self-defense, the principle of legal clarity. And as an example, I can give you of the following case. Not long ago, when I was head of one of the departments at the Court of Cassation, and there was a law that had been passed recently, and it made it possible to raise the issue at a court on the about the conformity of this law to the French Constitution. If the judge thinks that there are some doubts, he must submit this problem to the Constitutional Court, which plays the role of a filter towards we have the Cassation Court, to the Cassation Court, because the Cassation Court is a filter that filters out decisions that are submitted to the Constitutional Council in France. So this particular law stated that if you start a procedure aimed at finding out whether a French law is in conformity with European or EU agreements, and here the judge had to first to consider the issue of the constitutionality of those provisions. We raised this issue in Luxembourg, and it was said there that you cannot dismiss the European law in favor of domestic law, so the judge can immediately submit the case to the Luxembourg court. And even if the text said, the text of the law said that you have to first be guided by national legislation, this interpretation started to prevail in our system following the decision by the court in Luxembourg. Another right is the right for justice. And there was a significant influence on the prosecutor's office in my country after the decisions taken by the court in Strasbourg and the European Court of Human Rights, and we also, according to that decision, we had to change our case law So, and this means that the Strasbourg case law has a direct impact on our national system. Those were changes of the conditions of keeping people under arrest, and we had to abolish our law because it didn't conform to the principles stated in the European Convention for Human Rights. Those was a rule on temporary detention, and we changed our French law accordingly. Of course, we are under significant influence of the European law, and this is true for all the 47 countries that are signatories to the European Convention for Human Rights. And European law has an impact on the 27 countries represented at the court in Luxembourg. Also, it is necessary for national jurisdictions to cooperate between one another, but first and foremost they need to cooperate with international laws, and very often we see that all the judges appointed to the Cassation Court as interns or sent for an internship, and they are sent to both, the judges of the Cassation Court are sent for internships both to Strasbourg and Luxembourg, and we had very intensive exchanges of that kind, which proved to be very useful for us. In order not to take too much of your time, I would like also to say that this influence of the European law is quite significant. It has led to the predominance of the European law over national law, and most of the rules that we apply today are a result of the European law, meaning EU directives or the European Convention on Human Rights. And, well, what is going on in my country, France, and the other European countries is the convergence, gradual convergence of legal systems, both in terms of legal texts and judicial procedures. This is a process that is currently underway in Europe. Thank you very much. I would like now to give the floor to Mr. Niels Grubbe, Judge of the Supreme Court of Denmark. He is also well known because he speaks Russian. And he used to work as a teacher, as a professor, if we take a look at his CV, which did not prevent him from becoming a judge of the Supreme Court. And I would like to give the floor to him. Mr. Grubbe, you have the floor. First of all, I would like to thank the organizers for inviting me to participate in this forum, which gives me an opportunity to once again visit my beloved city. As Alexander Pushkin said, I love you, the creation of Peter the Great, about St. Petersburg, especially at this time of year where the white nights will come soon, and we know, as again Pushkin wrote, one dawn comes to follows another dawn, giving the night only 30 minutes of darkness, more or less. I would like to thank you for the privilege to participate in this roundtable discussion as well. Unfortunately, we cannot continue talking about Russian poetry. We should speak about legal issues, and in this case I prefer to speak English. For me, the Russian language is the language of culture and literature and history. Since the topic is different here, I would switch over to English. But first, I would like to
give a very few comments on the issues already dealt with. That is the cooperation between national courts and international courts. I'm a judge at the Supreme Court of Denmark, and we have cooperation both with the European Court of Human Rights and, of course, with the Court of the EU. It's quite different seen from a national point of view how the cooperation goes on. Of course, we have lots of cooperation with individual judges, and it's very effective. But I'm thinking in our work, the Court of Human Rights took some very important decisions, and the Convention of Human Rights is part of Danish legislation as of now. So all this thinking has had a very big impact on the jurisprudence of Denmark. But as the situation is now, there are two serious problems, and they are very serious. One is the delay in decisions. I think delay in judicial decisions is the most serious problem all over Europe, on a national level and on an international level. And especially the Court of Human Rights has suffered very much under the situation where the workload impressed to the court is not balanced with the capacity of the court. There's been lots of discussions about limiting those cases who could go to the court. It has not been accepted politically, and as of now, the capacity of the court is quite unbalanced to the workload, which gives the situation that when we take a decision on a national level, in the Supreme Court, which would be the third instance, of course, the litigators had the possibility to go to Strasbourg, and after maybe 8 years or something like it, we'll have a decision from Strasbourg. So it really, because of this delay of time, it doesn't impose very much on our daily business. The other situation that contains problems is that, of course, the court works case by case, and it must be that way. But we feel that sometimes the outcome of a case is very difficult to predict. And as a consequence of that, for instance, concerning the right, I could give an example of Article 8 of the right of family, which we have in cases where an alien has committed crime in Denmark and is supposed to have to leave the country, and we have to consider the human rights of keeping the family together. It would be naturally that we decided our cases on the basis of the case law of the Court of Human Rights. But in fact, we have found it very difficult because there are lots of different decisions and they are not always coherent as we see it. So we have evolved a practice of Danish jurisprudence in this field, and this is the primary source of our decision. If the result of this is that the criminal is allowed to stay in Denmark, we have no problems with the Court of Human Rights. If the result is that he has to leave Denmark, of course we must check whether there should be some case law from Strasbourg that would oppose to the result that we reached. But in that way, the impact of the case law of Strasbourg is only very indirect, and that's a problem in the day-to-day cooperation. However, I was asked also to take up another issue that really has my heart. I'm a Supreme Court judge, but I was formerly the chairman of the Danish Court Administration and has been working in ENCJ, European Network for Councils for the Judiciary, for several years in the steering committee. And one aspect which is very important in Europe in these days is the ensuring of the independence of the judiciary power. I think in the traditional European thinking stressed very much the importance of the independence of the individual judge. His personal independence, that he could not be dismissed, and the functional independence that nobody could influence on his decisions. But there has been a trend throughout the last, I don't know how many, 15, 20 years, of stressing also the importance of the independence of the judiciary as such, the independence of the courts. vis-à-vis the executive and the parliament. And what's contained in this independence? It's the independence in financing. The judiciary in itself should be given a sum of money to carry out the work, but it should be the judiciary itself or organs within the judiciary that decides on the distribution of money, the allocation to courts. It's a question of organization. It should be open to the judiciary to organize the work between the courts, to have the possibility of reallocating, for instance, judges to a court where a backlog situation arises, in order to effectively deal with what's their task, namely to taking decisions in due time. Also, the recruitment of judges is a very important situation that should not lie within the executive or the parliament, but should rest with some board within the judiciary that on a loyal basis, without any trying to seek any influence, political or otherwise, would decide who is the best man to get the new job. It's we all are familiar with the problem of dismissing a judge, but the problem of recruiting new judges and promoting new judges is also very important to the independence of the system. Also, the general administration of courts should lie with the courts themselves. I'm thinking about technology, of housing, of staff and other things. And performance management, how to deal with the cases, should lie also within the judiciary. Of course, respecting the right of the parliament to give the major procedural rules, but within these rules given by legislation, it should be open for the courts themselves to decide. Of course, when you're giving the freedom of independence, you have to assume also the accountability, and connected with the independence should be a system within the judiciary of control and reaction, a possibility of initiating new legislation, and the possibility of working on image protection, working with the media, which is in these days quite an important issue in many countries. In several countries in Europe, there's been an evolution throughout the last 15, 20 years towards such independence. It's organized in several different ways. In many countries, the independent board will be called the Councils for the Judiciary, which would be the normal expression in Southern Europe. Northern Europe more uses the word Court of Administration, the administration of courts, and in some countries the power is given to the Supreme Court. But what is essential is that these structures seeking the independence of the judiciary should be governed by a board consisting not only of judges, but with the majority being judges, elected by judges, in order to secure independence. And it's important that such boards and such administrations are independent of the executive, that they cannot receive orders from the Ministry of Justice, and that their decisions would not be appealed to the Ministry of Justice. There is a different situation all over Europe. In very many countries, the situation is, as I described. I think the NCJ has membership of something like 21, 22 European countries which have a situation similar to what I described. But another several European countries has not yet got such structural independence for the judiciary. I think it's very important that to keep in mind that as the task of the judiciary is checking and balancing to ensure the constitutionality and the legitimacy of legislation and the executive. It is important that the judiciary, as a separate power in the system, is allowed to have a self-governance independent of the other two powers. But it should be borne in mind that if such independence is established, it isn't established and must be linked to accountability, because the judiciary, of course, is at service at the democratic power, and the judiciary, of course, must also always remember that they have not a democratic mandate to decide the contents of the decision. These are based on legislation, and also the overall situation concerning legislation and the budget. The national budget is, of course, a matter of the parliament. So, but within these limits, the independence and ensuring the independence not only of the individual judge, but also of the judiciary as such, is a very important issue, I think, all over Europe and in other countries as well. Thank you.
Indeed, the issue of the independence of the judiciary is as important as an issue of independence of a specific judge, because these are interacted and one can't exist without the other. There cannot be an independent judge in a non-independent system and vice versa. Once, during one of the visits to Russia, the Ministry of Justice of the French Republic, Mr. Pascal Clément, we had a discussion whether it is necessary to provide for the independence of courts from the Ministry of Justice. Well, he found out that the Ministry of Justice did not participate in the budgeting, and he was very much surprised. But he put forward a very interesting statement. But I am a representative of the winning party that formed the government after the election, so we have the right to define how to fund the judiciary. And you are appointed by the president, so you are far away from the public at large. I didn't subscribe to such arguments, but we must bear it in mind that such opinions may exist. And it is also an interesting issue for discussion, because the authorities of justice and courts disputes have existed for a long time, and they carry on. Each of them think that they are right. And now I would like to grant the floor to a judge of the Supreme Court of Singapore, Mr. Chang Seng-on. I would like to highlight the tangible achievements of the Supreme Court of Singapore in terms of independence and in terms of capitalizing on information technologies. The floor is yours, please.
Thank you very much, Mr. Chairman, for the kind introduction. I would like to thank the organizing committee for inviting me to participate in this forum and to take part in this dialogue session. For me, this is the first time that I've stepped foot on Russia, and I'm extremely glad that the first city I arrived in Russia is St. Petersburg, which I found to be so magnificent. It's full of culture and full of history. And I'm indeed very privileged to be here today to share some of my thoughts with you. And I think I will start off with the independence of the judiciary and You have heard from the previous speakers, and let me explain how in Singapore we preserve the independence of the judiciary. Independence of the judiciary, in our view, is a very important asset as far as we are concerned. The government of Singapore, the various ministers of justice, Minister of Finance, all believe in the independence of the judiciary, and in Parliament, they maintain and put out a stand so that the public will also perceive that they, as a government, believe in the independence of the judiciary. That's a very good starting point. From that, the Minister of Finance will ensure that our judiciary will be adequately resourced in terms of budget. Because with budget, you can do a lot of things. What they allocate to us is a block budget. Of course, we have to compete with the Health Ministry, the Defense Ministry. Everybody wants money. But we have got a limited budget. But it doesn't mean that the judiciary is the last one to receive the money. We must have a fair proportion of the budget in order to enable the judiciary on its own to manage their block budget by itself under the directions of the Chief Justice and its registrar. Now, a part of the independence of the judiciary also is to ensure that the judges themselves are well paid. I think if the judges are well paid, then you have them not being susceptible to influence of corruption. And it may seem that paying $1 million US dollars to a judge seems a lot. But if you think about it, we have only about 17 judges in the Supreme Court as a whole. Even if it's 20 million to pay to the judges, the difference is that investors have confidence in the judges and in the quality of the judges. The reason why we need to have quality judges is because we recruit judges from the bar, from the senior counsel. And these senior counsel, they do earn a lot of money when they're in the private sector attending to their business. And if you were to pay them just a tiny sum of money, we will not get quality judges. This is what the government believes in. So independence of judiciary does not only mean that you have constitutional protection, which I'll come to later. It also means that they must be adequately paid and they must have some respectability in terms of quality, in terms of their remuneration, in terms of the status in the country. Now, how do we protect it in the Constitution as far as independence is concerned? First, a Constitution cannot be changed without 2/3 Parliament majority. Now, there is a section in our Constitution which specifically states about the independence of the judiciary. No judge is to be removed from his position unless with due cause. And with due cause, it must mean that they must form a panel of 5 judges which are not from the same country. One from the same country, the other 4, they will get from other countries in the Commonwealth to sit. Because if all 5 are from the same country, the government can well influence. There's a perception of that. So he cannot be removed unless with a panel. And number 2 is that the judiciary has got tenure. Tenure means that he cannot be forced out of office and he cannot be made to resign, and he has got the job until the age of 65. Of course, thereafter, if he's good, he can be renewed thereafter. Then with the question of delays, which I've heard the previous speaker talk about, how do we manage the backlog? Now, if there are adequate resources given to the government, to the judiciary, we can manage by engaging more judges to clear the backlog. Because at the end of the day, a backlog cannot be cleared by simply expediting the cases. If the cases do take that amount of time, we cannot rush it. Otherwise, what is rushed, you don't get justice. You make sure that the parties have adequate opportunity to present their cases to you. You have to hear the cases. There's only one man can only do one hearing at a time. So if there's a backlog, we must have enough judges to clear them. And how do we determine, how do we expedite cases? Well, judges are also told that they have timelines. It may seem a bit strange to have timelines in order to deliver their written decisions. Because if you don't have timelines, sometimes judges take their own, we call it own sweet time to deliver. So there are preset timelines by the Chief Justice. These are not dictated by the executive. They are dictated by the Chief Justice, who has control over all his own judges. This does not amount to the lack of independence. It really means that there's a certain amount of administrative directions which the Chief Justice must dictate to his judges. So we have, after hearing a case, 3 months, for example, to deliver a written decision. If it's an ordinary decision, of course, if it's a difficult decision, it will take 1 year. And the Chief Justice can take that into account in prescribing the bonus that one gives to the judges. There's a bonus system in the sense that there's a fixed salary and the bonus is at the discretion of Chief Justice. But so far, as far as I understand it, every judge has been given the same bonus because the Chief Judge doesn't want to be seen to be too dictatorial. But the point is made that there is a system of review by the Chief Justice as to the performance of a judge. Now, now I move on to the other area of IT in the courts. Now, in the Singapore courts, it has been a difficult journey as far as IT is concerned. We started on having paperless courts, so to speak, in inverted commas, paperless courts, as far as 10 years ago, where there's electronic filing, where parties can file their pleadings and so on electronically into the courts. They can serve their pleadings on the opposing party electronically, and the court system of hearing would be based on what I call television screens, called monitors. At the same time, the judge will not be given written authorities. They are all formatted, gone into the system, and everything is picked out during the hearing on what I call it, a monitor screen. And I can relate to you one case which I did, and I think this also deals with the infrastructure. In one case which I did, it involved 5 or 6 parties with almost 20 lawyers in a civil case, and there's so many participants that our court infrastructure cannot take it, in the sense that we do not have a size of court that's normally built that can cater for a big crowd. I mean, I can give another example. For instance, if there's a terrorism crime, a terrorism trial, you may have 20 accused persons, and each accused person has 2 lawyers. The courtroom as built in our present new court building is a standard courtroom. How does one manage this sort of trial? What we did was we converted on a temporary basis the auditorium, the big auditorium within the court, and to put me on stage, basically. I was on stage, and all the tables were there. So the council, we put what I call it in a semicircular form, tables which are temporary made, and we have got microphones for them. We've got the back screen. The backdrop was a big screen where we flashed through all the documents that needs to be presented, and council needs to use them. And we did away with all the thick files. And it was a very quick trial. I mean, it was an efficient trial in the sense that there was no need to refer to this page, this volume. And can you imagine if there are arch files, that take 150 arch files, and the council will refer to volume 34, page 346. And after 1 minute of that, volume 72, page 132. Initially they were delivering these files to me, and after a while I said, please forget it. Please flash it on screen. And after that, everybody use it on screen. And if there are new documents, we use visualizers, and everything is on. If it's a transcript of what has been given in evidence, they pull it out through the screen to the transcribers. So everything is all done electronically, and I think it has made possible a difficult trial with lots of documents being done in a very simple and efficient manner. Now, in terms of convergence of legal traditions and in common law and civil law systems, what I found on a personal level is this: in the inquisitorial system, the French system, the judges are very active in asking questions and in the search of the truth. Whereas in our common law system, of which Singapore is, because we inherited that from the British, we were a former colony of the British, and it's a good system. Their system of trial is based on an adversarial system where the judges try not to enter the arena. They don't ask any questions, only limited if they need to clarify anything. Otherwise, they'll be seen to assist one party or the other. So they leave it to the lawyers on both sides to cross-examine, to put their best case forward. Now, and of course, there are certain difficulties with that, because lawyers, if you're on one side, they only present the best evidence and they hide those which are not in their favor. At the end of the day, the judge has to decide what is the truth. So how do I balance it now? There's no restriction as far as we are concerned in our rules of court that we cannot ask any questions. So what I do is I have to actively, sometimes where lawyers refuse to ask the questions which are key questions, I have to go in and ask in order to clarify. Because at the end of the day, it is I who have to decide. And if I decide wrongly, the two parties will basically have a poor impression of the judge. The one who has managed to lie to the judge and win the case will say he's a stupid judge. And the other one who loses, and also, he will also say he's a stupid judge. So the best is to ensure that as far as possible, one gets to make the right decision. The right decision is more, in my view, more important than following just mere procedures, fair trial procedures. Of course, that's important, but critically, the bottom line must be to make sure that the decision is the right one. Now, for our Court of Appeal, that Court of Appeal decisions are, of course, binding on our courts, on the High Court. Now, what the Court of Appeal has recently done in order to simplify matters is to, in its decisions, set down basically areas of law which they list out as though it's like a code form. To say the law is like this. After reviewing all the history of the cases, they set it out in the decision itself. And that means that lawyers will only refer to that decision if they need to refer to a particular area of law, and we discourage them from digging out loads and loads of cases which basically build up costs only as far as we are concerned. So the Court of Appeal has, in that way, if I use other words, codified the law into the judgment itself. And because the judgments themselves are binding, in that sense we have incorporated the good features of the civil law system into a common law system. And I think as a judge, I'd rather prefer to refer to one decision which sets out clearly all the law in the Court of Appeal decision than to refer to maybe 20 cases on different points which may not exactly be the same and which at the end of the day may well confuse me. And I think I've said, I've got other points here, but I think I'll just stop now and to allow more time for other speakers. Thank you very much, Mr. Chairman.
So, selective use of precedents is a very interesting approach, yes. And now, I would like to give the floor to Mr. Michael Swainston, Royal Lawyer, Brick Court Chambers, who practiced in many different spheres of law, in international commercial disputes, in arbitration, in human rights violations cases. Therefore, he can speak on a wide range of issues discussed here.
Distinguished guests, I wonder if it's... I'm sorry. I wonder if as my first point, I could ask for the return of the remote control, which might illuminate proceedings. Thank you very much. Thank you. I've been asked to speak on two topics. The first is convergence of the legal traditions of common law and civil law countries. Now, we've heard this morning, and it's almost anticipated in the title of this topic, that there are significant distinctions between these two traditions. And it's very true that they are distinct legal traditions, and they have distinct features. But I would like to start with some common ground. Both systems believe in the rule of law. And even though they may have disagreed from time to time as to what the law should be, or as to how it should be implemented, they have normally arrived at a sensible consensus approach. I found an early happy example of convergence in the context of diplomatic immunity. I'm afraid it's quite old, and it comes from a dusty old book. In the materials, I'm afraid we're less successful with technology here than Singapore. I've got one, right.
Yeah, it's here. It's here. And let George control it, and George will take care. You will say, and he will change the slides. All right?
All right. Well, if we could have, I think, slide 4, that would be marvellous. Because I've reproduced for you. That will stop there.
Yeah,
perfect.
sure.
Thank you. It comes from a dusty old book. We've got a picture there of Blackstone, who was a very distinguished English judge who prepared commentaries of the laws of England. And they were first published in 1765. In some ways, they are almost a codification of the law, as you might find in civil law systems. Now, Blackstone tells the story of how in 1708 Peter the Great sent a new ambassador to London. And starting something of a Russian tradition in London, the ambassador bought a lot of things there. Unfortunately, his creditors alleged that he didn't pay for them. And one of the creditors arrested him for debt. In those days, debtors used to go to the Clink prison until either they or their relatives found the money to pay. Now, Queen Anne learned of the arrest before the ambassador reached the Clink prison, and she managed to have him released because she knew that it was contrary to the law of nations to interfere with ambassadors. Unfortunately, when Peter the Great heard that his ambassador had been arrested, he didn't take the news at all well. He wrote to Queen Anne and demanded that everybody who had been involved or who had known about it and authorized it should be executed. The Queen's response was a model of diplomatic drafting. She explained that whilst she was the monarch and head of state, such were the constitutional constraints on her position that she could not execute even the meanest of her subjects except according to the law of the land. And she went on to point out that whilst it was against the law of nations to interfere with ambassadors, it was not yet part of the domestic law of England that ambassadors should be protected. But she undertook that Parliament would pass legislation to correct that error, and in due course she sent a special emissary with a copy of an Act of Parliament, which is the foundation for the Vienna Convention on Diplomatic Relations, because it was adopted around the world. And graciously, Peter the Great accepted this as a full discharge of this diplomatic slight, and peaceful relations were restored. Now, this story, I would suggest, has several virtues in the context of our present discussion of convergence. First, it's mildly amusing and very topical in St. Petersburg. But secondly, it illustrates through the pages of Blackstone an old tradition, even in England, of attempting to codify the law, a tradition more associated with the civil law systems than the common law. But thirdly, it also shows ancient regard for comparative study of the laws of different countries in order to arrive at an international legal consensus. All of this is well reflected in the conception of this St. Petersburg Forum. So, what movement do we see in terms of convergence between the common law and civil law in terms of substance? I would like to talk about two, one bad and one good. I'll deal with the bad one first so that we can end on a happier note. For a long time, the European Commission has pursued a project of harmonizing contract law in Europe. The project is known as the Common Frame of Reference, and I was one of the UK delegates to the working groups involved. The Commission considers that a common law of contract, by which it has in mind the civil law commonly applied throughout the European Union, would be a good thing. It would be good for suppliers who would not have to trouble about different contracts in different European countries, and it would be good for legal business because lawyers everywhere in Europe would be producing the same paper. There would be, if you like, a single legal currency in Europe. That must surely be a recipe for success. What could possibly go wrong with a single currency? Of course, this is a bad idea for all of the reasons that comparative law is good. First, it stifles diversity. It cuts down on the scope of for development of different legal solutions in different countries and selection of the best by a process of legal Darwinianism. And secondly, and more fundamentally, it ignores the fact that the market for legal services, as we heard this morning in the plenary session, is global. And as we're beginning to learn, it is dangerous to ignore the judgments of the market. Clifford Chance, the international law firm, did some research in the context of the Common Frame of Reference project in 2005. It showed the following. First, that 26% of international business contracts across the world were governed by English law. And in some areas, like banking and insurance, the percentage was very much higher. Secondly, the most popular second choice of law out of the European systems was French law at around 11%, and German law came in at 10%. When the respondents to the survey who favoured their own law were excluded from the results, those choosing English law went up to 49%. And that was only English law. If you take in common law analogues around the world, then other competing systems went down to decimal points in terms of the freedom of choice of business parties and what they wanted to see in their law. And I would suggest, therefore, that English law has some features of contract which are quite distinctive and which business likes. In particular, the certainty that comes from an absence of pre-contractual duties of disclosure and rigorous regard for the choice of the parties when it comes to the effect of contract terms. And it follows that it was always going to be impractical for Europe to come up with a single currency of contract which business would use. Business would go elsewhere, and in this modern global legal world, there are plenty of places to go. That brings me to the second and happier aspect of convergence. There is increasing competition between systems of law to govern international transactions, and there's increasing competition for the business of dispute resolution, which very often follows the choice of governing law. What are the most popular offerings? Well, London is well represented. More than 80% of the cases in the commercial court in London involve foreign parties, and in more than half of the cases there, all of the parties are foreign parties who have chosen to go to the commercial court. And in the London Court of International Arbitration, some 80% of its cases involve all foreign parties who have chosen the English procedural approach at least. However, in my view, the most exciting prospects for the future lie with developing jurisdictions which have chosen a fusion of the best features of common law and civil law systems. And two good examples are Dubai and Qatar. Perhaps we could look at slide 17. If we're up to 17, not quite. A little bit right. That will be back one. At any rate, in materials which I would be happy to supply, I've set out some provisions from the laws in Dubai and Qatar, which have adopted a fusion approach. Both have adopted codification of their law, but they've done it in a very inclusive way. They've gone around the world selecting what they regard as the best features of different systems of law, and they've incorporated them in their own codes. But secondly, they have recognized that one attraction of English law is its relative predictability, which comes from precedent. And my slide 11 is a quotation from Tennyson, which sets out rather more eloquently than me the beautiful effect of precedent. Its effect in terms of certainty for business parties is this: whether your source law comes from a statute or from a civil code, precedent can help to interpret it in a consistent way, and it can help to fill the gaps, because however clever your draftsman of a statute or a civil code, there will always be gaps and ambiguities, and it's good that the courts can supply the certainty in a new situation where a draftsman could never have anticipated the problem. Finally, the new hybrid centres have an attractive hybrid approach to procedure, and so they adopt a common law procedure when it comes to evidence, with orders for disclosure of documents, oral evidence in open court, and cross-examination. But at the same time, as our Singapore colleague has demonstrated, the judges in common law and civil law systems tend now to be almost equivalently interventionist. An example would be the way that judges in the commercial court in London or in Qatar or Dubai will intervene and identify preliminary issues which, if decided first, might resolve an entire case at substantially less cost to the parties and with much less delay. So we live in a brave new world where the established legal systems, in my submission, could not safely rest upon their laurels. If they do, as in so many areas, the old world will find itself losing ground to the new. The second thing that I've been asked to talk about, and happily and fortuitously we have the right slide, is the issue of ensuring the independence of the judiciary. And I start by confessing that I'm not the best person to talk about the independence of judges, because I'm an advocate who appears in front of judges, and therefore it would be a bad idea to upset any of them, especially the very distinguished judges that we have here today. So I'll do my best to negotiate choppy waters. I began my observations today by noting that both common law and civil law systems have at their heart respect for the rule of law. And there's scope for debate about some nuances of the rule of law, because it's a phrase that's more often used than defined. But nonetheless, some elements are fundamental and beyond controversy. And again, in the materials, I've set some of those out from standard sources. But the most interesting source, again, is a dusty old one. It's a list of personal resolutions written by Sir Matthew Hale, who was a famous Chief Justice in England in the 17th century. And he set out a set of resolutions to guide his own conduct as a judge, which achieved currency amongst judges at the time and fame since. And it's a very exacting list, and perhaps the judges amongst us could measure their private performance by these standards and see how they fare. If I were a judge, I would find some of them very, very difficult, particularly number 6, which is not to be prepossessed with any judgment at all until all the business and all of the argument of both parties has been heard to the full. Probably the most difficult in the sumptuous surroundings and the enormous hospitality that we're enjoying in St. Petersburg is the last one, which is to be short and sparing at meals that I might be fitter for business. Very difficult in the context of the banquets to which we've been treated. I would suggest that aside from that last item, that list should not be controversial amongst any of the lawyers here as embodying, in the most attractive language of its time, the essence of a good judge. This is judicial independence. But it's important to have in mind that whilst this list embodies independence of mind, it does not entail independence in the negative sense of being detached from society and the interests of society. On the contrary, in item 1, Sir Matthew recognised that in administering justice, he was carrying out a trust for God, King and country. And items 8 and 10 involve a balancing of different interests in society in order to achieve justice for everyone, going beyond the particular case. And Sir Matthew would certainly have been rooted in the legal society of his time. He would have been a member of an Inn of Court, of which there are 4, and there's a picture of one of them on slide 15. It might be possible to identify that one. Now, the inns are societies of barristers which celebrate independence. It's supposed to be fearless advocacy, which involves going on even after the chairman has looked at his watch. But the important point is this, that a judge who was controversial, who was stepping beyond his bounds, would be reminded not to by his peers over dinner in Lincoln's Inn. We don't have, for international courts, such as the ones represented here, the equivalent of a Lincoln's Inn. But what we do have is the St. Petersburg Legal Forum, which offers plenty of opportunities to sit next to very distinguished judges and to bend their ear occasionally. Thank you.
У нас осталось
We have a number of persons who would like to participate in the discussion. And then I will grant the floor to Valery Zorkin, the chairman of the Constitutional Court of Russia. And now I would like to grant a possibility to make a comment to Mr. Stefan Garabin, who is the Chief Justice of the Supreme Court of Slovakia. Good afternoon. On behalf of the chairman, I would like to express my gratitude for the invitation to participate. Thank you, Mr. Chairman, and thank you, dear speakers. We would like to tell you about the independence of justice and to share experience that Slovakia has acquired over the last 2 years. New transformation that was initiated in Slovakia 2 years ago, in our opinion, bring our judiciary 20 years back in terms of independence. Independence is one of the integral parts for the efficient operation of the judiciary in a democratic society. lawmaking bodies, through adopted regulations, really limit the independence of the judiciary in Slovakia. I would like to explain why I said that the executive branch limits the independence of the judiciary. This was the opinion arrived at based on the laws adopted 2 years ago in a draft law on courts and judges. We can see the efforts of the ministry as an executive authority to exercise control over the judiciary through the introduction of changes into the composition of the commission that appoints judges. Most of the members of such commission are appointed by the Ministry of Justice, which means that actually the appointment of judges in Slovakia is politicized. 5 members of the commission, out of the 5 members of the commission, 3 are elected by the Ministry of Justice. Another intervention of the executive branch includes the following. The relations of justices in proceedings. From the Council of Judges, the powers were handed over with regard to the discipline proceeding to the Minister of Justice. Well, the discipline proceeding must not be may not be an instrument that can infringe justice. So actually, such an impact from the executive branch destroys the balance of power between different branches. Obviously, such changes in powers won't result in more trust to the government, but vice versa. It will generate suspicions with regard to the interference. The Ministry of Justice initiated a number of disciplinary cases with regard to the Chief Justice of the Court of Slovakia because he didn't subscribe to the adopted reforms and for expressing his own opinion. Weakened independence. Well, let me reformulate. The independence of courts and justices is supported by proper remuneration that actually must manifest the high status of judges. It must protect judges from any pressure in terms of awarding judgments and must have an impact on the behavior of judges. And actually, we are urging the executive branch to adopt any measures that may question the financial independence of judges and ensuring the rule of law. But these requests were ignored, and in 2010 the budget of the judiciary was reduced by 10%, while other authorities had only a 5% reduction. Such funding cuts were interpreted as the abuse of power by the executive branch and resulted in the deterioration of the conditions of Slovakian courts and the judiciary as a whole. Concerns about the processes pertaining to the independence of the Slovakian judiciary judiciary were raised by Dr. Gerhard Reisner, the chair of the International Association of Judges, who sent a letter to the Minister of Justice, Madam Zhitninska, with regard to the development of the situation that impedes the free development of the judiciary in Slovakia. Mr. Reisner wrote, there is concern that certain directions of the development of the judiciary in Slovakia is actually a step back. If the balance of power is violated, that will result in a weaker judiciary. In order to increase confidence, a state governed by the rule of law cannot accept changes and amendments that are not democratic. Instruments must guarantee transparency of all procedures, including administration, self-regulation for judges who will combat successfully against the abuse of powers. The Association of Judges of Slovakia, as an independent self-regulatory body, turned to the European Association of Judges with a request to analyze legislative amendments pertaining to the judiciary. Such an analysis was carried out with regard to the appointment and tenure of judges, the process of setting up activities for judges, and disciplinary and career growth of judges. Based on the review, on the 4th of September in 2011, the European Association of Judges adopted a resolution unanimously where it expressed concern with the fact that most of the amendments to the Slovakian legislation were not in conformity with international standards. And have a huge impact on the independence of the judiciary in Slovakia. At the end, we would like to say that all draft laws that have been adopted in Slovakia with regard to the judiciary hasn't been signed by the President of Slovakia. So they are all currently reviewed by the Constitutional Court, and actually some of them were suspended because of the non-compliance with the Slovakian Constitution. Thank you for your attention. If you have any questions, we would be happy to answer them.
Tatiana Nishataeva, a judge of the Eurasian Community Court. She would like to say a few words about... Well, she will explain herself. I am happy to present to your attention a new international court at the request of my colleague judges. We followed the same route, the route of convergence, but I think that we will be more successful because our approach is based on international law and international agreement. It's going to be very similar to the European Court. In the future, we think that we are going to work with the European Court in Luxembourg, and the first procedural rule of this court was adopted yesterday. It is like a Russian doll, and some people think that our decisions are have a power of recommendations, but our recommendations are not going to work. But Eurasian community Eurosec will expire in 2012, and the Court of the New Economic Community, which will be called the Court of the Eurasian Community, has already been set up. We have 6 judges already appointed. We adopted rules of procedure yesterday. We received 2 cases, exactly like the judge from Luxembourg explained. One is about steel and one is about coal. So we are starting exactly from the same level from which Europe started some time ago. All the supreme and constitutional courts of participating countries, if they take a decision that is final, and if they want to interpret international agreements and treaties, and there are 17 of them in force already, and by the 1st of January 2015 there are going to be 52 agreements, they have to apply to us, and we need to make a decision with regard to the interpretation. If the judges deviate from our interpretation, we submit our decision, in this case, to the Council of the 3 heads of state. And the rules of procedure that were adopted yesterday deal with those entities that can apply to our court in terms of exercising our supervisory function. Well, first they have to talk to the national government, but the first cases has shown that this will probably won't work like that. The committee hasn't yet been set up, and we received letters asking us to remove this requirement of the administrative procedure. They tell us, please do not deprive us of the access to justice. And here we will be guided by what the court in Strasbourg said. Stating that the access to court should never be restricted in any way. Despite the fact that the union will be created in 2015, the committee, the commission rather, the supranational body has started to work, and right away citizens have complaints against the decisions by national authorities. Now we are faced with a huge task of starting this work, and I do remember all the warnings from my colleagues. Number one, Mr. Kovler, be conservative, he said, be conservative. And conservative, once again, I swear to God that we are always be very conservative. We will be moving towards the preservation of national identity in the decision of national courts. I know Anatoly Kovler, I know the Court of Luxembourg. Not a single international court in the world has been able to comply with this requirement. Therefore, I have to apologize in advance. We are going to be conservative, we are going to respect you, but probably we will go beyond the frame of our reference. And finally, I do hope that we will always meet with one another, we will always communicate, we are going to be friends, we are going to learn from European courts of law, we are going to learn from other national courts, but the problems that we are going to be faced with will come up. I do not sleep at night now. I keep thinking about these problems. So the problems are going to be threefold. Since we are very different, the mentality are very different between the 3 countries, although we share the Soviet past, it will be very difficult to overcome. But finally the Europeans managed to overcome this. The second problem is lack of specialization. We could not elect judges in accordance with what was written in the convention. We have very different backgrounds amongst the judges, and we have to lecture one another, which usually results in battles. And the third problem is the worst, probably, the lack of freedom. When I tried to formulate what this lack of freedom is all about, it came out like this: lack of freedom from our geography. We are all from the East, and Russians understand me, as our told us, geography is like a sentence. We have to get rid of this lack of freedom. We must get rid of this lack of freedom. And what provokes outbursts of laughter, but still we put it into this rules of procedure. We should not be engaged in inadequate relations. We know that we will have to do a lot to learn how to be free from those issues. I'm not going to further expand, but of course I am ready to write a treatise on each of those negative things that I mentioned above, including the lack of freedom. The Higher Court of Arbitration gave me a right only to say a couple of words. Therefore, I complete my intervention, and I hope that we will meet on in our quarters when we will be ready to. When we will prepare to hold conferences like this. So please make friends with my fellow judges who are for the first time in this room and feel tense probably. Thank you very much. There is another negative factor that you will experience. It's the fun. It's a play upon words. All the factors started with no, and the name of the speaker also started with a no. So in conclusion, I would like to give the floor to Valery Zorky, the chairman of the Constitutional Court of the Russian Federation. We can talk a lot about the independence of the judiciary. It is easy to talk about this independence. Those people find it easy to talk who have never been who have never suffered from the attempts to undermine this independence. Mr. Zorkin suffered from it and survived, and he earned a deep respect for that.
Thank you very much. I will skip all words of thanks, congratulations and so on. So please think that I have pronounced all of them. Since my topic is about the interaction of supranational courts and national courts, and here we need to take into account higher courts, especially the Constitutional Court with due respect to the higher commercial courts. First of all, I would like to give a metaphor with regard to this interaction. There is a violin concerto of Mozart, number 45. There is the leading fiddle, secondary musical instruments, and so on and so forth. And imagine that there are two scores instead of one. So this is exactly the interaction of a supranational court, by which we first of all understand the court in Strasbourg, but we also have the newly founded sort, but there is also the International Criminal Court, where Russia does not participate, the USA doesn't participate, either China does not participate, but many do. So, with all this metaphor, it's very important that two scores, so the regulatory framework that guides an intergovernmental court, like a convention and constitution, must be identical. It seems to me that this is exactly what we have, so there should not be problems in terms of human rights and freedoms, because these are abstract standards, and they are talking about the same, but it is important to ensure the simultaneous nature and the symphonic type of nature. No one should try to impose anything on the other, so no unison is allowed, neither is cacophony. So that's why, since I don't want to test your tolerance and patience, I would like to mention a problem of whether judges are right or judges' activism is right. Logically, I would like to say that setting up any judicial or legal order doesn't go from law to judges and enforcement, but from courts to law and developed enforcement. Take, for example, a book of judges, the Strasbourg Court. Actually, the Strasbourg Court acts at its own discretion, creating a single European space. Unlike Constitutional Court, the Strasbourg Court has only an abstract convention, but it doesn't have a system of law, I mean intergovernmental law, within which it operates. And it is making certain steps, and it is going forward. Well, we should cheer these efforts, and we need to appreciate them, but there are a lot of dangers here. And dangers are about the fact that a small aristocratic judges' body, which has no counterbalances in forms of a certain lawmaking body and executive body at the national level, because actually the Committee of Ministers is something else. It takes the risk of not taking into account the main aim of symphony and harmony, and it runs the risk of imposing on behalf of all participants certain things without taking into account their peculiarities. Please understand me right. It's not like either specificity or standards. We must combine both. Putting it together is a work of art, not only for the European Court, but also for the higher courts of countries, because otherwise we'll be faced with conflicts and confrontations. So let's be frank. We are now in the professional community with the outstanding lawyers. When one of the speakers was talking, I somehow remembered Lewis Carroll with Alice in Wonderland. And Alice says to the king, listen, you are going to execute a criminal, but where is your sentence? And the king answers, the sentence will be made tomorrow. We are executing him today. So talking about young democracies, some refined professors, I would say, not lawyers, have approximately the same idea of what's happening in this part of Eastern Europe. Otherwise, how can we understand the following thing? In a recently published book, which is called Das System Putin, when Putin served his last presidential term, well, the following thing is included in it. What can we say about the judiciary in Russia when the Constitutional Court was relocated from Moscow to St. Petersburg? While everyone knows that in Moscow, outside the ring road, Siberia starts.
What shall we do after all this? So, one of my colleagues, one of the two co-authors of this book, a very respected professor in the West, well, not only professor. I gave her my book, where I devoted a special chapter to this fragment. What we're trying to do? Are we trying to reset the situation? Are we trying to create a legal space in which independent courts of law will operate, just courts, no matter whether they are located at the Ministry of Justice, as a significant part of it, as in France, because officially France doesn't have the third branch of power, but I don't think that in France court decisions are worse than in Russia. This cannot be the case, or in the UK. Old man Blackstone, whom you mentioned, what did he say? He was talking about the omnipotence of Parliament, but not even the Parliament can do everything. I'm not quoting, but, well, I'm trying to interpret him in modern words. He said the English Parliament cannot regulate the conversion of a man into a woman because it is not possible. But life has changed, and now the British Parliament can issue such edicts. Now we are approaching another very important problem, the problem of a living constitution. So a living instrument, right? That is why I was talking about the violin and all of the drums. So this living instrument lives in time. It should not lag behind life, because if it lags behind life, people will say, let's put this instrument on a shelf or in a back room, and it will stay and collect dust there. This instrument that is called the European Convention for Human Rights, because when it was adopted, we didn't have the internet, we didn't have many other things either, and now we have everything at our disposal, and we need to interpret these things. The Constitution, the Convention must be alive, living. But where are the limits in the harmony of national and universal? I'm talking about the Strasbourg court, but it applies equally to any international court and any national supreme court. It is faced with exactly the same problem, and this interaction, interplay, occurs at the backdrop of these problems. I will give you just one example. I'm not going to talk about Officer Markin. Well, some people know the story probably. For the benefit of the judge of the new court. She was very aggressive with me. Well, what did Markin do? When on the day when his wife gave birth to a child, Mr. Markin divorced his wife, and he went to the court in Strasbourg, and he received the rights to grow up a child. But now, I don't know whether he will go, and then everything was taken again from him. But I'm not good. I don't know when the second child is born. He is going to go to the court in Strasbourg. I'm not going to offend Officer Markin or whoever else. So it's very difficult to excite you. If everything will work out in your court, yeah, everything will work out in your court. Yes, I'm sure. And then we're faced with a more serious problem, and it is no time for laughter. If the European Court decided not about the crucifixion in Italy, but about certain Muslim attributes or symbols that are now under the European Convention, what is useful in Amsterdam will lead to a tragedy in Makhachkala in Dagestan. And it turned out to that it led to a tragedy not in Makachkala but in Serbia, where mass cleansing took place. Well, lack of mental delicacy, lack of abstract understanding of the evolution of legal norms is not useful. Therefore, I especially bring your attention to this fact, because it is important both for the European Court and for the constitutional courts. And I think it is very important that on this path, as the Brighton Conference recommended, we should study the experience of one another. And the Constitutional Court, the Supreme Court of Arbitration, whatever, can study the case law of the European Court and maybe ask them for advice. But this road, or rather a bridge between supranational and national courts, is a bridge with a two-way traffic. And maybe Strasbourg, when they take a decision on a case, they cannot study all the 47 case laws of national courts, but they can ask them, how do you solve such model cases in this and that country? And maybe collect some fragmentary evidence. Then certain decisions wouldn't probably be taken that created a lot of confusion, at least in Eastern Europe, such as a decision about Guerrilla Kononov, where they equated officers of the Allies with those who fought on the side of Hitler, Wehrmacht. And a Soviet soldier, an officer, helped guerrillas. Yes, they created an ad hoc tribunal, and they said that this was not an administration of justice. But if tomorrow a similar accusation will be put forward in the Czech Republic or Slovakia to the Czech and Slovak guerrillas who captured the butcher Gay Heydrich and executed him. And I talked to some, well, not exactly judges in France, but people who finance the judiciary system there. And one highly placed lady told me this is a totally different story. What does it mean, a totally different story? Does it mean that in the Soviet Union people fought like in Alice in Wonderland, or like in that book commenting on where Siberia starts? So I think that those issues are quite serious. We need to take into account the fact that Supreme Courts are not against the court in Strasbourg. There's other supranational courts, and the future court that is going to be, it's not in existence now. They haven't taken a single decision yet. But the supranational courts are not against national courts. We must go along this road together, hand in hand. And this journey was started by the court in Strasbourg, setting the case law. And if we have a universal pan-European space, or spaces, or a global space even higher than that, we need to create a unified single legal space. This is the way towards, this is the strategy we should pursue globally. We should not we shouldn't oppose abstract to the concrete. Democracy, of course, means the protection of minorities, but the minority should not again be above the majority. It means that every weak voice should be heard, like in Russian philosophy. I think that this road is the most useful, and we need to support the efforts of the court in Strasbourg. But how about the case of Markin? Well, yes, one professor in my country said, "What do you want from this old man Zorkin, who can only urge you not to fulfill the decision of the court of Strasbourg? That's the only thing he's good for. He's just sitting in his constitutional court, the former Senate, and mumbling away crazy things." But I would like to say to our international guests, in our 20 or 21 years of this epoch, there was just one case that was a kind of a dialogue with the court in Strasbourg. We didn't have any conflict, because we thought that this situation with Markin was considered from the point of view of the protection of child, the protection of men and women in specific conditions of Russia. Strasbourg and the big chamber, they have made a step in our direction. They have taken away the mention of the Constitutional Court. That's good. That's a good first step. They've offered a compromise model. But, well, based on that case, shall we once again repeat that the Constitutional Court is extremely angry that it is under the Kremlin, that the Constitutional Court judges receive huge salaries and do nothing? Or shall we consider the situation seriously? We are not going to turn this into a circus. We need to support these efforts critically, but support. When Anatoly finishes his term in the court of Strasbourg, let him come to the Constitutional Court and share experience. When Mr. Bonder finishes his term with the Constitutional Court, he should go to Strasbourg, and then it doesn't matter how the judiciary system is to be financed, by itself or from the budget. For those who doubt things that what I said today, you can find these ideas of mine in two internet interviews, one on the site of the Russian Gazette, and the other is called The Imperative of Security, and the second has today been placed on the site of the Constitutional Court of Russia under the title Interaction between Supranational and National Courts and Global Conditions. Thank you very much. I understand that I can win a round of applause if I say that I'm not going to summarize this session. I will just tell you that a lot of very different ideas were expressed here with regard to judiciary independence and interaction between national and supranational courts, which once again underscores the acuteness of these problems and their contradictory nature. And of course, here we cannot have one and for all decisions. We need to cooperate in order to attain mutual understanding. This is the main goal that will allow us to resolve our national problems and our external problems. Thank you for participation. The forum will continue. I hope to see you many more times.